everybody, Valerie Zammitti of Zammitti Law, where we provide peace of mind to families through estate planning, elder law, and probate matters. In the next few minutes, we're going to answer the question of why a small business owner may want to avoid probate. Before we get there, however, if you have any questions about this topic or anything estate planning or probate related, you can reach out to us for a free conversation at yourplanningattorney.com. That's yourplanningattorney.com. Now, we have many small business owner clients, and so it takes a little bit for us to walk them through the scenario as to what could happen should they pass owning those interests in their business individually, as opposed to some other method, which we'll share in a few minutes. First off, when you are a small business owner, if you're building it the right way with systems in place, and proven profitability over the years, there certainly is a value there that you can pass on to your beneficiaries. Now, quite frankly, whether or not there is a value there, at the end of the day, if those interests are owned individually, your membership interest if it's an LLC, or your shares if it's an S Corp, would have to go through a probate process at your passing. And with that, as we all know, a probate does incorporate some additional costs as well as delay. So if there is a time sensitivity to any of the transactions with regard to the business, without someone in place to act on behalf of the business, it could create a whole hubbub. And so what do we do about this, right? We don't want to have that delay. We don't want to be forced through the court to present a formal valuation of that business at a time when you need to be doing other things, or your family really needs to be doing other things. And so we look to make sure that when we're establishing our estate plan, we have some sort of metric in place to provide sort of a rule of thumb for the valuation of our business. And it's advisable to utilize a revocable living trust to which you would assign your interest in your business so that the probate process is avoided completely. With that, your trustee falls into your footsteps and allows for them to take control and do what needs to be done to sell that business or to transition in some way if there are partners, without creating more confusion and delay. In addition, it's helpful that every business have an agreement in place to make clear what should happen when, so that those trustees can follow through with your wishes and explanations. It's our suggestion that you should, as a business owner, have a little instruction in case you become incapacitated or at your passing, of some of the nuances that are not clear via an estate plan, but need to be there and present with some instruction for those folks. We hope this information is useful, and as always, if you want to talk about this topic or anything estate planning or probate related, you can reach out to us for a free conversation at yourplanningattorney.com. That's yourplanningattorney.com. Thank you so much for watching again. And if you like this information, please share, like, and subscribe where appropriate so you and others don't miss out. Again, Valerie Zammitti of Zammitti Law, where we provide peace of mind to families through estate planning, elder law, and probate matters. See ya.